Our next guest is State Representative John Walsh. He was elected to first term in the Michigan House of Representatives in November of 2008, representing residents of Livonia. He's a graduate of Michigan State University in 1984 and then attended Wayne State University Law School, graduating in 1987. He is also the chair of the Judiciary Committee and has sponsored a variety of bills addressing the perceived concerns of the Michigan Medical Marijuana Act. Representative, can you hear us?
I can indeed, and thank you for having me on tonight.
It's my pleasure.
Thanks for calling in.
Thanks for joining us.
Sure.
There's a lot of things that people in our community are, interested in and want to discuss, and I appreciate you coming on and talking. Just a little background. My name is Michael Kamorn. I'm an attorney. I've been practicing law for about 18 years and have been representing primarily medical marijuana patients and caregivers in the last 3 or 4 years. In the studio with me is Chad and Jamie Lowell and a patient, Mike McShane.
Good evening.
Caregiver Peanut Butter and Rick Thompson.
Hello.
Hello, everyone.
So one of the questions that a lot of people have been asking, and I'm curious to know, why do you think that, if at all, the law needs to be changed? What are the exact problems that you perceive need to be fixed?
Well, what we're witnessing, Mike, is dissatisfaction on a number of levels. Almost all stakeholders in the matter. You've got patients that are holding a legitimate certificate, and some of them are being raided or they're in fear of being raided. You've got police agencies that aren't certain exactly what to do and when to do their enforcement actions. You have zoning officials in various municipalities not certain what they can allow and not allow. And so what we're hoping to do we have an 8-bill package. Now not all 8 bills may or may not pass, but what we're trying to do is address systematically areas of the law where we think we can improve the definitions and still meet the desires of our voting public. The public clearly authorized medical marijuana. I accept that. And what our goal is, at least in the House Judiciary Committee, is to just try and provide some additional definition to the situation so that we don't have so much what I would call near chaotic situations.
Do you perceive the current state of things in chaos?
Well, when we're sitting in our offices in Lansing or coming back to the district, nearly every one of the House members, 110 members, has a story to tell about somebody that was raided, somebody that received a certificate under suspicious circumstances, let's call them, maybe over the Internet. That's troublesome to me and many others. Or you might hear a police officer that says, we keep getting these phone calls a neighbor called, I think I have a drug operation next door. They have to respond to it. That's an officer off the street when, in fact, it's a caregiver. So it's troublesome. It's got people bothered, and it's. I don't think we should have citizens afraid. We shouldn't be wasting police officers' time. I just think we need to clean it up a bit.
Yes, but even the things that you mentioned, such as someone getting raided who may have been a patient or a caregiver, that's not a problem that's created by someone from within the community per se. That's an issue of administration and whatnot. That's not a problem per se that's coming from some bad acts by the medical marijuana community. You're not speaking of, and that's really what I'm asking. Like, do you see the issues that need to be addressed? Coming from patients. I mean, are they doing something wrong, or caregivers per se that are doing something specifically wrong, or is it more or less just defining things?
I think it's more or less defining things. We could go on and discuss cases that might be underway, or was this a wrong act by a patient or a caregiver or not? All I'm trying to do, along with my colleagues, is in taking in input from people like yourselves and patients and officers, police officers, and so on, is just to add some clarity to help out the situation so that people understand what their rights are.
Sure.
It would help if they could have a training program to train the officers and have everybody understand what this law is about, rather than everybody trying to fish around in the dark.
And this has been one of my points of interest, which is that, I was mentioning this, that, we all recognize that there's a fabric of, the fabric of our society of how we viewed, cannabis over the last 80 years. And this is a dramatic change to the way that things are going to be viewed. I mean, and we are all debating here on, how that interpretation of the law is going to be applied. But there has been very little, if any, attempt, I feel, and tell me if I'm wrong, about educating or changing the way law enforcement should be addressing the medical marijuana community. Would you agree with that?
Well, I think it's hard to say in general. Every community is different. There's no statewide training program of which I'm aware. So I'd agree with you on that level. What they're doing at local police departments, I really don't know. There are almost 2,000 municipalities in the state, and everyone's going to approach the situation differently.
Right. Well, I, of course, hear and see the worst of it because part of my practice, my majority of my practice is criminal defense, so I'm seeing the situations where, there's allegations or you have law enforcement arrests and what I would describe as, medical situations or, technical issues, technical violations. And while I don't see much, and I spend a lot of time talking to the police officers, that there isn't any direct training. There's no, consistent training, and if it is anything, it's usually, a police directive, and it's not something that it involves the communication from the medical marijuana community. But one of the things that's been troubling to me as a lawyer is that, and I don't know how much the legislature is aware of this, but, the presentation of the medical marijuana defense before juries has been precluded in majority of the cases. And I know you're a lawyer, and I know you went to Wayne Law. I'm a U of D person myself. But, what we were taught in law school, like this concept of the right to present a jury trial is the most sacred of our rights. Mm-hmm. And it's just, when I tell people, other lawyers, that, they're like, how can you be precluded from presenting, a medical marijuana defense when they, their whole intent or their mens rea was, involved with their card and what they believed, and just to present. And this has been taken away. And my view is that the change will come if the juries are able to hear these cases and have they be the ones that are deciding whether it's medical or not. And to me, as we sit here 4 years into it, this has been absent. And I was wondering, is the legislature, the committee that you're working with, is this ever a discussion, about, I'd call it like a right to fairly litigate these cases? I don't know, some way to kind of honor, the right to present a defense on these cases.
Mike, this is the first time that I've heard that, and I will discuss it with. There's a couple of lead representatives on the Judiciary Committee, Ken Horn out of the Saginaw area, and Phil Kavanaugh, who I think's been on your show. He mentioned that he had appeared.
He's going to come back next week too, I think.
Is that right?
Yes,
I'll talk to the two of them because I had not heard that. We've certainly talked broadly about the law and the patient-caregiver relationship and the doctor-patient relationship, zoning issues, but I've not heard that. Being able to present a defense is core to our principles, and I find that assertion troubling. Now, I'm going to want to look into it because I've not heard that before, but if that is the case, it is something we ought to look into.
You may have come in late, but the woman who was on before you is a woman from Oakland County. She's, I said, a young-looking 70-year-old grandmother. She just had another grandmother. She was charged with, her house was raided and her husband had left and the door was open when the police came in, and her husband later died of a heart attack. And when they went to court, because the door was open, it wasn't locked and enclosed as the law presumes, and some of the case law that's come out from the Court of Appeals. She was not allowed to have a affirmative defense. She was not allowed to mention medical marijuana card. And as she was saying earlier, the jury was sending out notes, is she a medical marijuana patient? And the judge told them that she could not answer that and to ignore it 3 times. I've had many cases myself where, we're precluded from this. And I know that, the idea has been the Court of Appeals decisions. They reference it as, if you're in violation of the act at all, any aspect of the act, you cannot use it. It becomes irrelevant to the presentation. You have and I have my last 3 or 4 clients that have come in are likewise 65-year-old couples that are in court over these technical violations, and the prosecutors are filing motions to preclude a defense. I don't want to beat that one down, but I'm glad that you are interested in that.
It's something that we could look at, maybe some kind of a materiality level. Right. I'm not sure what that would be off the cuff, but I will certainly pursue that with Rep. Horn and Rep. Kavanaugh.
I appreciate that. And just as a matter of, I always felt that, instead of whatever money would be required by the state to actually have a, consistent, teaching or education for law enforcement across the state, I really honestly feel that had many of these cases had an opportunity to get to a jury, the law enforcement would more or less be compelled to reevaluate, and prosecutors would be rethinking their position on whether or not they wanted to prosecute for technical violations or or just let it go, because they're realizing that when these cases go to trial, the juries don't want to convict. And it puts more of the decisions of some of these things back in the the jury pool. But anyways, that's one thing. All right, so let me ask you this. I know you're from the great city of Livonia. I actually do a lot of practicing of law out there. I like the judges. I love. It's a phenomenal police force. Nothing but great things to say about them. But Livonia is one of the cities that banned all medical marijuana use. What are your thoughts on that?
Well, they took a position that they that of course is done at the local level, and they felt that it was justified. What we're going to try and do, and Mike, we're not there yet in terms of working on the legislation, but the zoning issues are tied in with, and I'm going to get, this will be a roundabout answer to your question, I'll admit that, but I'll get to that. What we're hoping to do to address situations like that is address the distribution system in the totality. And there are a lot of models. You can do the caregiver model, which we already have under the legislation, or we can have a dispensary type model. While we're working on whatever the model may be, once we gain some consensus and at least can put a bill together for discussion purposes, we ought to be handling the issue of zoning. Right now, I think the city has the right to do that. Personally, I think that it could have been perhaps a little less restrictive. We do have a wide industrial belt that goes right through the middle of the city. If you're familiar with the city, roughly from Schoolcraft Road to Plymouth and the entire 6-mile length then east and west, there would be opportunities within that area. If the concern is having a dispensary operation in the neighborhood, for instance, or perhaps you zone it to a business or a commercial area. There's other ways to handle it. And I think if we can adjust the distribution system in a manner that people understand and is not so threatening, and also require certain zoning, and requires the wrong word, but at least set out guidelines, then we might avoid these cities that have an absolute ban.